check in at 11 a.m. I expect that we will have this motion argued and decided by then. So I too thought, did you, Christian? I thought that it was going to be a very quick sort of thing, that she would hear the defense out and that we would go right back into questioning jurors. Lo and behold, that was not what happened today.
And Christian, this decision is not only a surprise, it opens up just a huge set of problems. Where, when, how much is it going to cost? All these things, months probably.
We could be in Waycross in October when the trial begins. We don't know where and when. It's probably going to be the fall. I was told by the court administrator that it's going to take a while. They got to find a county willing to take it on, and basically everything moves down there. It'll be the same judge, the same court personnel, obviously the same lawyers. Everything else will be the same except for the jurors.
WSB legal analyst Ron Carlson is live on the phone. He's been with us all afternoon. And Ron, this is not unprecedented. It's happened. We've talked about some of the cases in the past, which they have moved to other locales. Tell us a little bit about what all is involved. You're talking about logistics. You're talking about lodging. You're talking about a huge cadre of media, in particular in this case.
Absolutely, and the things you just mentioned, Chris, are in the Georgia statute, which controls this change of venue procedure. Let me say before I make a few points, Chris, great riding this roller coaster with you today. Understandably, it was a surprise. Christian Boone's excellent article on Saturday, Dad's Lawyers Seek Change of Venue, he quoted two outstanding criminal defense lawyers from Marietta. The first said, "I find it very unlikely she would grant a change of venue." And the second one said, the motion largely intended, and again I quote, "for use on appeal." So the second lawyer was saying the defense is simply making a record here, and Judge Staley provided a surprise to almost all legal observers. Now, Chris, your point, what all goes into a change of venue? The rules of the superior courts provide first, when a criminal action is transferred, the same judge stays in charge and goes there to where the county is, what's called the transfer county, that the case is going to be tried in. And then the Georgia statutes say the judge of the trial, Mary Staley in this case, will confer with the chief superior court judge of the circuit where the transfer is going to go as to, A, the existing criminal and civil trial calendars of the transfer county, which county shall be responsible for court security, prisoner security, securing the meals for jurors, which county will guarantee and pay the vendors for the services. So there are a lot of details to be worked out, and that's what's coming up next.
Channel 2 Action News reporter Ross Cavitz live with us as well. He was in court today. And Ross, one of the reasons this was so startling today is that they were literally very nearly done with the jury selection.
Yeah, the judge wanted 42. We got up to a 41 at one point. They did eliminate one today, so we were back down to 40, but really only a few more jurors needed to be interviewed before we got to that point where we were going to be able to slice and dice and do the final strikes on jurors and then get this trial started. We were counting on opening statements maybe Wednesday of this week, so we were very close. I'll be honest with you, the timing of the motion, although it surprised many people, many lawyers I talked to said they did it at exactly the right time when they got a good representation of the 250 jurors they called to the courthouse. We'd gone through about 90 of them, and that was a pretty good sample of what the mood was among these jurors. And as you heard the judge say earlier today, that mood was not positive when it came toward defendant Ross Harris.
Judge Staley talked about the media coverage, how much there had been, the publicity and so forth. Ronnie, help me with the timeline here. You guys had the arguments this morning there in the courthouse.
Right.
They came back. She said 1:30. You guys came back at 1:30. She said, you lawyers go back and try to figure it out yourselves.
She essentially punted.
Yeah, punt. I sent you a message in huge capital
punt.
letters, punt.
Yes.
That's right. But then at 3 o'clock.
And then at 3 o'clock, she, after laying out all the reasons that it would be so uncomfortable for us to move the trial, we skip ahead, and that's what she ends up doing. Now, to be fair, she had the lawyers to get together and see if they could confer to find some sort of answer. So just to let people know what's happening. So Ross was talking about the 41 jurors that we had pre-qualified for the jury pool. Six of those potential jurors had actually been qualified for the pool. So in this motion here on this page of the motion, you have these folks down here where the defense listed as the ones who have all these biases. And you can see that these lists, this number goes on and these are all pages of juror opinions talking about how they think that Ross Harris is guilty, should get the death penalty, people need justice for Cooper and that kind of thing. So some of these might seem a little like you don't need to talk about them because they're ousted from the jury pool, right? But a half dozen of them actually were qualified to sit on the jury. Prosecutor Chuck Boring said we have enough jurors now to actually seat an impartial jury. But the defense said this is no way with the case law that we can cite. Statistically, we're not getting a good representation of impartial jurors, and it's not going to happen. So we had those arguments, and the judge talked about what the people had said on their questionnaires, how strong the emotions were, and then she said, we're going to move the trial.
Let's hear from Judge Staley now. Andrew Longoria, if you can cue up our first soundbite. This was her announcing the decision. It was about 10 past 3 this afternoon. She discusses all that, lays out her reasoning here, and then drops that bombshell at the end.
To say that the juror questionnaires show a pervasive knowledge and extreme opinions that are negative to the defendant is frankly an understatement. And then the testimony. They come to court, and the testimony corroborates what the questionnaires show. Although some jurors did, in fact, change their opinion, but about as many who said on the questionnaires they could be fair and impartial came to court and said they could not be fair and impartial. And then the other was true. Some who said they could not be, when they testified, said they could be. And then we have the percentages. If you use the state's percentages, which are lower, you're in the mid-40s. If you use the defenses, which are higher, you're in the mid-50s for those struck. And then, other than a cold record and the questionnaires, what should be reflected in decision-making is what happened in this courtroom. And this courtroom has not been a place of mild opinions. And a cold questionnaire doesn't give you the sense of what the jurors are saying, of how they are responding. The defendant has carried their burden to make a substantive showing of a likelihood that the prejudice exists because of extensive publicity, so that it would not be just to try the case in Cobb County. So I grant the defendant's motion 26 for a change of venue.
That is Judge Mary Staley at the Cobb County Courthouse, and Ross Cavett, Channel 2 Action News. The judge alluded to this. Veronica just alluded to it. You guys heard every kind of person, just one after the other, this last 2.5 weeks with some version of course he did it.
We did, and when you sit there and you listen to that over and over again, you start to fail the so-called smell test. It just didn't sit right that so many jurors came in, and sure, if they'd have continued to pound away at these jurors for we did it for 2.5 weeks, and then it kept going and going and whittling through the 250. They're going to eventually come up with 42 that promise to be fair and impartial in court. When you have so many that are saying that they have rock solid opinions about Ross Harris's guilt, it really didn't sit well, and certainly did not with the judge. You heard her comments there. And I also say, and Veronica and Christian can back me up, this came after a pretty stern lecture by the judge when she came back at 1:30 telling the lawyers, listen, you got to realize what we're getting into here. A change of venue is not an easy thing, especially for attorneys. The defense attorneys, they're going to have to relocate to somewhere else. They'll be away from their support structure in their offices and their homes. And for everybody else, it's going to be a change of lifestyle, not just a change of venue.
Did you guys get the sense, Christian and Ronnie, at any time in the past, especially most recently, in the past few days, that this was just not going to fly here?
Well, what's interesting about this is the Judge Staley's known as a prosecutor's judge. He's a former prosecutor. So a lot of people thought that alone would make it tough for them to get a change of venue. But had we been back in those negotiations after she had given the order to the defense and the state to see if you can hammer this out, we probably would have known what was coming, because the defense held firm. They're like, we want all these 5 jurors. It was 5 or 6. I think one of them had been dismissed. But anyway.
There was one that was out for 6,
right.
But then one out for hardship, yeah.
We want all these jurors dismissed, and we're not there may be other things there may be other jurors we have questions about. And the state was like, well, we'll disqualify too. Obviously, the defense knew that they had hand right there, and
Right.
they
About 1 minute.
were correct.
Yeah, so I was just, we were talking about earlier about the Lynn Turner case and how we had to move the first trial of Lynn Turner, the accused Black widow killer who had killed her husband and her boyfriend separately with antifreeze. And so we had jury selection there in Cobb County, and Judge Jim Boterford was the judge in that case. And he asked the jury pool, how many of you have heard, read, or seen something about this case? Stand up. And in the words of former District Attorney Pat Head, it sounded like a herd of buffalo. Everybody in that room just about stood up. So she said, Judge, maybe it'd be better if we ask who hasn't heard about it. There were 3 people who hadn't heard. But we still went through the process and did about 20 voir dire questionings of the potential jurors. And then when the last woman said, I think she's guilty as homemade sin, Judge Jim Boterford said, you know what, it's time to move this trial.
And Lynn Turner was represented by Vic Reynolds, now the
And yes,
Cobb
that's
DA.
right. Vic Reynolds, the current DA, was one of her defense attorneys.
It is a small world. Coming up on 20 past 7 here, News 95.5 and AM 750 WSB. Our special program to continue until 8 o'clock. Mark Aram starting a couple hours early tonight at 8 o'clock. His show runs from 8 until midnight tonight. He'll take your telephone calls of reaction to this news. From court today, it is a really stunning development in this already very high-profile, very controversial trial. Reporters were set to go. The lawyers were set to go as soon as tomorrow, as you're hearing. Instead, it's going to be months before this trial gets underway. More about this decision and what it means next on WSB.